All right, well, like Joe said, my name is Nick Adams. I'm an attorney from the Pemberton Law Firm, so we've got an office here in Wadena, just right over on the corner by the Cozy Theater. So the Pemberton Law Firm is the name of the firm. Might or might not have heard of it. There's a bunch of different attorneys at our firm. All of us do slightly different areas of law. There's some of us, I guess, that focus primarily on estate planning, which is what I do personally. So this is kind of what I do day in and day out, is meet with people and talk about their estate planning needs. So that's kind of what today's going to be. It's going to be more of an informational session. Obviously, each of you have slightly different scenarios and concerns, but generally speaking, there's some consistent themes that people talk about. So that's what I'm going to try to do today, is kind of touch on those most common issues. But just know, obviously, I'm going to leave here today knowing these are the exact documents that I need, and here's why, and feel like you have it 100% down. Don't worry if you feel like it's trying to drink through a fire hose. There's going to be a lot of information in a hurry. So if anything you hear today is interesting to you and sounds like something to talk about, then the next step would be reaching out to me, and then schedule an actual one meeting where we take a look at your scenario, specifically talking about your family, your finances, your specific goals and desires and wishes, so we can make it a lot more personalized. So with that said, some of these slides, you're going to take a look at them and you're going to go, that doesn't apply to me at all. I don't care about that. And that's okay. I apologize about that. That, again, not all of you are going to find every last one of these slides. So again, today's presentation, we're really going to focus on three areas. The three things that I say any estate plan ought to cover is, first, right now, the types of plans that there are, the probate versus non-probate plans, and then minimizing and avoiding taxes, and then also doing some disability planning. Mic not on, maybe?
Mic's just popping in and out.
Oh, sorry about that. There we go. We'll try that. Hopefully that works a little bit better. All right, so keeping going, what is an estate plan? Estate plan is kind of the umbrella term for all of the different types of documents that you might have. So there isn't one single document called an estate plan. But it's the process of making sure that after you pass away or if you become incapacitated, all your wishes get followed through with. So there's a few different reasons why you might want an estate plan. But again, long story short, it's mostly about efficiency. Again, one last thing as I'm going through these slides is I might go through them a little bit quickly. If you go through or if you see any of the stuff that I've got put on here today and you say, oh, that's kind of helpful, but Nick didn't spend a whole lot of time on it, I've got a couple copies of my card on the back table there. You can grab a card, shoot me an email, or give me a call, and I can always either print off a copy of the slides or just email you a copy of it if you just want to spend a little bit more time reading through it. Again, there's going to be a lot of information on the slides. I'm not going to try to read every last word that's on all of the slides because that can get to be pretty boring for you. So there's a few different types of estate plans. Some of these common documents here you may have heard of. The most common one that people have heard of is a will. I'm going to kind of harp on wills a little bit because, to be frank, they're not as powerful as most people think that they are. And I'll kind of explain what I mean by that as we're going through the different documents here. One overarching theme that I like to say for any estate plan is that we want to cover three specific scenarios. First scenario is right now, while you're alive, alert, awake, and healthy, and able to make the decisions for yourself, I don't like to do anything that's irrevocable or that takes your power and control away. So I've got a heavy preference towards keeping things revocable when and if we can. Second scenario that we want to plan for is if you do become incapacitated, making sure that we have your documents in place set up to say that you get to be the person who makes the decisions on who gets to make those decisions for you. And I'll talk about some common misconceptions that people have with some of those documents. And then the third and final scenario that we want to plan for is after you pass away, where does everything go? But not just where does it go, also how do we get it there as efficiently as possible? And that efficiency piece kind of means different things for different people, but one of the common things is how do we avoid probate? So we'll talk about avoiding probate. We'll talk about how the nursing home works a little bit. So that's medical assistance specifically. That's an area that's obviously very focused on you as an individual. So I won't spend too much time talking about medical assistance because, again, that would be something that's very particular and precise to you. And then the other thing that we want to talk about is avoiding capital gains tax. That's another tax that can be kind of a kicker. So these are a few of the different types of documents. Again, first one's a will. A will essentially says where you want your assets to go after you pass away. Unfortunately, and if you remember one thing from today's presentation, it's that a will does not avoid probate. So I don't know how many of you have heard about the probate process or know exactly what it is, but we want to make sure that there's some extra documents along with your will to make sure that we can avoid that probate process. So the first thing that we need to determine is whether a probate is necessary. That first determination is not based on whether you have a will or not. It's based on what types of assets you own and how they're titled. So the first of two scenarios that would trigger a probate would be if you have more than $75,000 worth of assets in your name that do not have a beneficiary listed on them. Second thing that would trigger a probate would be if you have any ownership interest in real estate in your own name that, again, does not have a beneficiary listed on it. So what is probate? Long story short, it's the long drawn-out process of the court giving us a whole bunch of hoops we need to jump through just to get your assets to your beneficiaries. The problem with probate is I usually estimate that they take somewhere between about 8 and 14 months and usually cost somewhere between about 8 and 12 grand. So they're really expensive and they take a really long time just to get your assets to your beneficiaries. Again, I'm going to say it a second time. If you remember one thing from today's presentation, it's that a will alone does not avoid probate in those two scenarios. So if a will doesn't avoid probate, the next logical question for most people is, well then, what the heck does? And the good news is there are a whole bunch of other ways that we can still avoid probate, but it isn't as simple as just writing up one document called your will, having you sign it, and being done with it. So remember, the two things that trigger a probate are any ownership interest in real estate in your own name or more than $75,000 worth of other assets in your own name that don't have beneficiaries listed. These are some of the tools that we can use to make sure you don't actually fall into either of those categories. First tool is called joint tenancy. Essentially what that is owning an asset with another person. You're joint owners on it, or you might have heard it described as joint tenancy with right of survivorship. If you're married, this is probably how most of you own your bank accounts or your real estate. It says essentially if one of us passes away, I want it to go to the surviving spouse. That's great. We can get that transferred without having to go through a probate. There's still a little bit of paperwork that needs to be done, but it's a couple weeks, couple $100, pretty easy process. The real issue occurs mostly when the second spouse passes away. You don't likely have your kids listed as joint owners on your accounts or on your real estate. And to be frank, I wouldn't actually recommend adding them as joint owners or a joint owner on your house or on your real estate. For the reason being, if hypothetically they're a joint owner on the home or on the bank accounts, and one of them gets in a car accident and gets sued, their creditor can then come after your account or after your home. It's an available asset for the child. Instead, we would want the kids to be listed as what are called payable on death beneficiaries, or just generally contingent beneficiaries. So again, kind of playing out the standard nuclear family where you got mom and dad and a couple of kids. If one spouse passes away, we want the second spouse as the joint owner, but then we want the kids listed as the beneficiaries. By doing so on all of your financial accounts, whenever the second of you would pass away, the kids can go talk to the bank directly and they can fill out the paperwork and they can say, hey banker, look at mom or dad or grandma or grandpa or aunt or uncle or whoever, whatever the relationship is, listed us as a beneficiary. The bank will then cut the check or cut the money to those beneficiaries. They have to use that money to pay off any bills or debts or expenses that you have, but then anything that's left over, they get to keep. And the best news is they get to keep it without having to go through that probate process. So I like to joke with people that I'm an attorney that doesn't like going to court. So you're going to hear me talking a bunch about ways that we can stay out of that probate process and try to reduce the amount of court or judge involvement that you might need. So remember, one of the terms is a payable on death beneficiary. Second one is just called a beneficiary designation. They effectively do the same thing, which is just listing your beneficiaries directly onto your accounts for after you pass away. And that's the key distinction between a beneficiary and a joint owner. So the terms beneficiary designation, payable on death, those are for the accounts. On the real estate, there's a very similar type of document. It's called a transfer on death deed. This document's relatively new in the grand scheme of things. It came out in Minnesota in 2008. but it does what most people think their will does, which is just says where their property goes after they pass away without having to get the court involved. Nice thing about a transfer on death deed is that it is 100% revocable. So if, hypothetically, you do a transfer on death deed that says, I want my house to go to my kids after I pass away, in the meantime, you still have 100% of that power and control. So if you decide you want to change your mind, or take out a mortgage, or sell the property, you don't need to ask anybody else for permission because you are still the one that owns it. But what a transfer on death does do is avoids probate after you pass away. So before I go on and kind of start talking about the next ways that we can avoid probate, I want to skip a few slides and do a little bit of a primer on how medical assistance works. So medical assistance is the county program that potentially pays your way in the nursing home if you financially qualify. And that last little bit, the if you financially qualify, is really important. So in order to financially qualify, if both spouses, assuming you're married, are still alive, you would have to spend your financial accounts down to about $154,000. At that threshold is when the county would step in and say, okay, have you made any gifts or done any uncompensated transfers in the last 5 years? That's called the 5-year look-back period. Generally speaking, if you've gifted away assets or sold them for less than what they're really worth in the last 5 years, the county can force you to go get those assets back. Now, there are some exceptions to that. And one of those exceptions is pre-planning or pre-funding a funeral. So I'll let Pat and Joe talk a little bit more about that, or Jeff talk a little bit more about that. So I'm not going to focus on the pre-funding. But just know for big assets like your real estate, if you give it to the kids, for 5 years the county can say either you got to go back and get that asset, or they're not going to give you a bed in the nursing home if you expect that the county's going to pay for it. So that threshold, again, if both of you are still alive and only one spouse is in the nursing home, is $154,000. At that point, the county can say you have to sell any non-homestead real estate. Any non-homestead real estate they force you to sell, you use the money, you pay for your care. Your home, they won't actually force you to sell as long as the spouse is still living there, or as long as you can get a doctor's note that says you have a chance of going back and living there. But if you can't get that note, or if the spouse isn't living there anymore, then theoretically they could force you to sell the house too. When the first spouse ends up going into the nursing home and spending all your money down to the threshold of $154,000, even if the spouse is still living in the home, they being the county, doesn't actually just let you keep it free and clear. What they do is they keep track of the bill that the county then starts paying on your behalf, and then after you would pass away, the county can attach that dollar amount as a lien against the real estate. Now the nice thing about the lien is that there isn't a certain time period where it has to be paid off by. It's not like the kids only get 30 days or 60 days to pay off that amount. But know that that amount would be there if the kids ever do decide to sell or transfer the property to somebody else. If that first spouse passes away and then the second spouse goes into the nursing home, now your financial threshold drops from $154,000 down to about $3,000. So that's obviously a whole lot less now that you can keep if only one of you is still alive or if both of you are in the nursing home. Then for real estate, the same analysis occurs. If you've given away any gifts or sold anything for less than what it's really worth in the last 5 years, the county can still go after it. If you've made it past that 5-year look-back period, then the county cannot go after the portion of the asset that you've given away. So oftentimes what a lot of people ask is, Nick, is there any way to protect the home from the nursing home or protect real estate from the nursing home? And what it kind of boils down to is there's really only 2 ways. First way is to have long-term care insurance, but for a lot of people that long-term care insurance is pretty expensive, so not many people actually want to pay the premiums. Or the second way is to give up the power and control over an asset and then wait 5 years, because again, there's that 5-year look-back period. Now, neither of those options are very great, just to be frank with you. But what I tell people all the time is that the state and the county, they're the ones who pay the medical assistance bills. They're also the ones who make the laws. So they're really dang good at making sure that there's no loophole where you can have the cake and eat it too, where you can keep power and control and have it be a protected asset. So it kind of comes down to that zero-sum game. Reason why I bring up that medical assistance little rundown prior to continuing through these different documents and how we avoid probate on the real estate is because the biggest distinction between the real estate documents often comes down to how they are impacting medical assistance. So that first one I've been talking about, transfer on death deed, because you keep 100% of the power and control, even after the 5 years, it does not protect the property from the nursing home or from medical assistance. It essentially just says, here's where I want it to go without having to go through a probate, but it would still be subject to any mortgages, liens, or encumbrances. The next option is called a life estate. With a life estate, essentially what you do is you say, I want to keep the right to live on and use the property while I'm still alive, but I'm giving the rights to the property for after I pass away to the kids already, or to the beneficiaries. And I should have mentioned this earlier, but when I say kids, it doesn't actually mean that it has to be your biological children. I just mean any beneficiary that you might have. So by giving the future rights to the property to those beneficiaries right now already, you're giving up some power and control. So the downside is if you decide you want to change your mind in the future, you want to change who it's going to go to, or you want to give it to somebody else right now, or you want to sell the property, unfortunately, you need to get those kids, and if they're married, their spouses, to consent to that transfer. Now, obviously, we can all think of a scenario where maybe you could kind of strong-arm the kids into doing what you want, but there might be one in-law who maybe is about to become an outlaw that might not be quite as interested in signing off on those deeds, giving that piece of real estate back to you. So I'm cautious whenever we talk about life estates, but long story short, you would keep the right to live on and use the property while you're still alive. You would give the future rights to the beneficiary already right now. And then the state would tell us what percentage of the value is associated with each of those sets of rights. So the good news is, the older you get, the county says your value in the real estate is worth less and less and less and less. And the reason for that is, remember, you only have the right to live there while you're still alive. So the good news then is if you would ever end up going into a nursing home and you would rack up a lien, after 5 years, the only percentage of the value of the property that the nursing home can go after is the value that's in your name still, or in your bucket. So unfortunately, we don't get to decide what those percentages are. The state tells us what they are every year. But at 76 is when it's about 50-50. At 85, it's about 40% in your name, 60% in the kids' names. And then at 95, it's about 30% in your name, 70% in the kids' names. So again, the reason why that can be helpful is after 5 years, if hypothetically you go into a nursing home and you have a $300,000 home and you have a 30% interest at the time, if you only rack up a $20,000 lien, well, the life estate doesn't really do you a lot of good. County can still go after the full $20,000. But if you may be going to the nursing home for 4 or 5 or 6 years and you rack up a $500,000 lien, if you've only got 30% of the $300,000 house in your bucket, that's about $90,000 of equity. Even if you have a $500,000 bill, county can only go after that $90,000 of it because that's all that's in your name still. So that means then the rest of the $210,000 or whatever the value would be is an exempt asset. The nursing home can't go after it even in the estate recovery. So it's a very particular or very specific scenario where people do actually feel comfortable giving up some of the rights to the property. But if that's something that you maybe would be interested in, we talk a lot more about you and your scenario and your finances and trying to decide whether the life estate does actually make sense for you or not. The next option is called a revocable living trust. A revocable living trust is essentially a bucket that you can put your assets into, and while you're still alive, you can still be the one who makes all the decisions regarding what happens with those assets. But that bucket already has rules and instructions on it that say what should happen with those assets after you pass away. Remember, you're the settlor, meaning the creator. You're also the trustee, meaning the one who has the power to make the decisions. Now, unfortunately, because you are the one that has all the power and control to make the decisions regarding the assets in that revocable living trust, even after 5 years, a revocable living trust does not protect the assets from the nursing home. So that's probably the second most common misconception that I hear. A lot of people think, oh, I took it out of my name. I put it into the trust's name. Unfortunately, if that asset still is being used for your care and has to be used for your care, the county says, nope, sorry, not good enough. That's still an available asset for you. So a trust isn't really designed to protect, or at least a revocable living trust, isn't really designed to protect assets from the nursing home. It's more so designed to, first, avoid probate. Second, to be able to put some extra rules and instructions on what you want to have happen with those assets after you pass away. So the trust does a really good job of kind of planning for all three of the scenarios that I have talked about, keeping power and control in your name right now, deciding who makes the decisions if you become incapacitated, and then also deciding about where those assets go after you pass away. Some of the common rules and instructions that people like with revocable living trusts is first, we can provide specifically for minor or disabled beneficiaries. So in Minnesota, the default is that as soon as your beneficiary turns 18, they can stick their hand out and they get 100% of the assets that they have coming to them, assuming you've already passed away. Nobody can stop them from doing a certain thing with their assets or with their inheritance. With a trust, we can put some extra rules and provisions on those assets, just in case maybe the kids are minors, or if maybe the children are disabled, or if maybe they just really don't make very good financial decisions. We can pick somebody else to be the one who helps make those decisions for them. So one of the most common ways of doing that planning is through what are called delayed distributions. So what a common delayed distribution scenario would be is that they'd get a third of their share when they turn 21, they'd get a half of what's left in their share when they turn 25, and then they'd get the rest of their share when they turn 30. But those ages are changeable. You could potentially say, oh, my kids are past these ages, I want to use 30, 35, and 40, or whatever numbers you might pick. But if we do put in delayed distributions like this, I oftentimes have the trustee, whoever's in charge after you pass away, have two really important powers. One of those powers is the power to make early distributions if they deem it necessary. So maybe those beneficiaries decide they want to go to college when they turn 18. And this might be grandkids now. Maybe it's not just your kids, but eventually money might be going to grandkids. So maybe they want to go to college, or maybe they want to buy a business, or they want to buy a house, or they're getting married, or they're having babies. Something that you think would be a good use of their inheritance before they reach these ages, your trustee does have the power to give them that money early. They also have the power, though, to postpone distributions even further if there's a verifiable reason. So something like a drug problem, an alcohol problem, a divorce, a bankruptcy, a creditor issue. Those are all things where you'd probably say, oh boy, even if my kid just turned 30, if they're in the middle of a divorce or in the middle of a bankruptcy, I probably don't want my money actually being distributed down to them. So your trustee would have the power to pump the brakes on it, make them get through that scenario, and then they'd be able to take their share. Other nice things about a trust is if you want some certain specific rules on real estate, like potentially I want the real estate to go equally to all the kids, but if in the future any of them decide they want to sell their shares, I want them to be legally obligated to offer it to the other siblings, maybe at a specified rate. That's often called a right of first refusal. We can put those rules into your trust to help make sure that the real estate stays in the family, or at least give the kids a chance to keep it in the family if they want to. You don't have to worry as much about one kid getting spiteful and deciding they want to sell it to Joe Schmo down the road. This next slide, supplemental needs trust. This only applies to people that have disabled beneficiaries. So a lot of people have heard that if your beneficiary is under some sort of disability and they're receiving some sort of government benefit, that they then cannot receive any inheritance. And that's generally true. If they receive inheritance, then the county can use that as an available asset, and it could potentially disqualify them from receiving an inheritance. But there's a very special type of trust called a supplemental needs trust, where we could put some extra rules and instructions on those assets, but it would exempt them from being counted as an available asset for that beneficiary. So again, if you do have a beneficiary who's maybe disabled and maybe receiving some government benefit that you have previously just written off and said, well, I can't ever leave money to them, just know there is a way that we could talk about it and we could see whether this makes sense for you or not. There's one other way that we can avoid probate on real estate that I like to at least mention, but not many people actually choose to do it. And that's just doing an outright gift or an outright deed to the kids. If we do an outright gift called a quitclaim deed, and we just transfer the real estate 100% to the kids. The nice thing is that after 5 years, then the county can't touch that piece of real estate because you've retained zero power and control. But the downside to that option is as soon as you give those kids that deed, that real estate is now theirs, and you again have zero power and control. So most of the time it's not an issue. But remember, if they would get in a car accident and get sued, then their creditor could come after that property. So specifically with your home, I very infrequently recommend actually giving it 100% to the kids. We could potentially do a life estate on it. That'd be a little bit safer for you because at least then you get the power to have the right to keep living there while you're still alive. But the other reason why we don't want to just deed all the real estate to the kids has to do with capital gains tax. So capital gains tax is the tax you'd pay If you buy an asset for $100, you sell it for $200, you pay tax on the difference. With real estate, if you gift that piece of real estate to the kids while you're still alive, they get gifted your cost basis in the property, meaning whatever you paid for it, that's their basis. And then in the future, if they would ever sell it, they'd have to pay capital gains tax on the difference between the sales price and your purchase price. So specifically for people who have owned real estate for a really long time, you might not actually want to give the property to the kids right now, because if you do, they get your cost basis, remember. But any of these other options we've been talking about, either transferring it pursuant to your will and having to go through a probate, or doing a transfer on death deed, or doing a life estate deed, all three of those options, or doing a revocable living trust, I should mention that one too, all four of those options give the kids what's called a step up in basis to whatever your date of death value is. So in that way, as the property keeps rising in value, the kids are essentially getting credit for all of that appreciation. Whenever you pass away, their cost basis gets set at your date of death value, and then if they sell it, they only pay capital gains tax on the difference between the sales price and your date of death value versus all the way back down to your purchase price if you had just given it to them 100% while you're still alive. So again, these sort of tax questions, the medical assistance planning, it's very specific to you and your finances and your kids' finances and, to be frank, your relationship with them and their relationship with each other. So we would definitely want to talk more in our one-on-one meetings about whether any of those gifting options actually make sense for you. But what I can tell you is, at the very least, if you own any real estate, you likely will want to do a transfer on death deed, where you can at the very least say, after I pass away, I want my house to go to my kids, and then it's theirs and they get to decide what they want to do with it, but at least they're not going to go spend a year and $10,000 stuck in the court process paying attorneys and paying the judge and paying the newspaper to publish it just to get access to the things that you've spent your whole life acquiring. There's a few other tools that we can use to avoid probate as well, on some business interests. Then there's also some different types of trusts that we can set up specifically for certain types of assets that you might own. This next category, I anticipate probably isn't going to apply to many of you. I know it doesn't apply to me personally, but it has to do with estate tax. Estate tax is the tax that you would pay based on the cumulative amount of all of the assets that you own. The good news is, if you're under some very specific thresholds, there is zero estate tax or death tax or inheritance tax that the kids need to worry about. If you're over the thresholds that I'll talk about, some of the ways that we can reduce those amounts are by giving gifts or setting up some certain types of entities or listing some charities as beneficiaries after you pass away. But once I get to these numbers is when you're going to probably say, yeah, Nick, this doesn't apply to most of us. So the federal level, as of 2022, when a little bit of an old slide here, was $12 million. It's gone up a little bit now, but you get the concept. Under $12 million, don't have to pay any estate tax from the federal level. The Minnesota level in 2024 is still the same as it was in 2022. That level's $3 million. Now, many of us don't need to worry about Minnesota estate tax as well, but some of you might. And if you do, all the more reason why you want to make sure you do your planning ahead of time, specifically if you're married. And here's why. With a properly set up revocable living trust plan, we can essentially double your estate tax exemption from $3 million really just when the second of you passes away to $3 million when each of you pass away, which essentially gives us a $6 million bucket as opposed to just one $3 million bucket. So again, this doesn't apply to many people, but if you do set up a meeting and you say, Nick, I remember from your presentation, you were talking about if we got a high level of assets, we ought to talk about it. Definitely mention that right from the beginning, and that'll kind of help decide what plan makes the most sense for you. But long story short, even if you're at $4 million, by doing a revocable living trust plan, we can essentially reduce your estate tax liability from $130,000 down to nothing. So again, pretty helpful if you fall into that bucket. Some other very similar scenarios are if you have a qualified small business or a qualified farm property, we can get some extra deductions for those. But those are really, again, only if you're over that $3 million threshold to start. Now I've just spent some time talking about how we make sure the assets go to the right people after you pass away. Now I really want to take a step back and talk about something that's more broadly applicable, because really whether you're 18 or 98, we all want to do some disability planning. And what I mean by that is making sure that if you become incapacitated, making sure that you can pick the person or the people who make the decisions for you without having to go through a really long and drawn-out process, an expensive process called a guardianship and a conservatorship. So a lot of people assume that if you're married or if you have adult kids and you become incapacitated, you don't really need to do anything because the next of kin can just automatically take over and start making the decisions for you. Unfortunately, that isn't true. If you don't have any documents in place and you can no longer make the medical or financial decisions for yourself, then what we would need to do is we need to go to the court and we need to do what's called a guardianship and a conservatorship. That's the court's process of the court taking that person's decision-making authority away and then the court getting to decide who makes those decisions. Now, most of the time they do pick that next of kin, the spouse or maybe the adult kids, but that process usually costs a few $1,000s and takes a little while to get through. And remember, I'm an attorney that doesn't like going to court, so that includes guardianships and conservatorships. Now, the good news is there are a couple of contracts that we can do ahead of time that drastically reduce the chance of having to do that guardianship and conservatorship. One of them is called a power of attorney. What a power of attorney does is it essentially says that you get the power to keep making all your own financial decisions, but you've already signed a contract that says, I trust that person or that order of people to also be able to make financial decisions. Generally, what the power of attorney does is it says it applies over any financial decision you can make for yourself as long as 3 caveats are met. First caveat, by law, it's only valid while you're still alive. As soon as you pass away, that's when the will or the trust or the beneficiary designations would kick in. Then, it's also only valid as long as you haven't revoked it, because this document is revocable, so you can make any changes whenever you would want to. And then third, it's only valid as long as what those people are doing is in your best interest. So if, hypothetically, you pick a kid to be the power of attorney, and then they go into your account and they start making decisions on your behalf that just really aren't in your best interest. They start taking out money and going on a vacation to Mexico. Well, that's fraud or theft the same way as if they forged a check on your behalf, so you would at least have a cause of action to try to get that money back from them. But what you ought to know is that a power of attorney is a very broad document, and it's actually valid as soon as you sign it. So most of the time they're set up that even if you're not incapacitated, as soon as you sign the document, it's valid. And the reason for that is the bankers, the financial advisors, the accountants, they don't want to have to decide whether you're incapacitated or not, so they want the document to be a whole lot more straightforward, just saying it's valid immediately. Now, one of the things that I like to point out whenever anybody does do a power of attorney is we want to make sure we have some backups listed, because if you are going to spend the time and the effort to decide who you would want making your decisions, a lot of times if you're married, it's each other first. We also want to do a little bit of advanced planning and think about, okay, well, who would be next in line? So in the power of attorney, there's spots where we can list some extra backups just to make sure you're not coming in, every couple of months if maybe something happens to one of your loved ones. So power of attorney only applies to financial decisions. Next document is the healthcare directive. So the healthcare directive essentially says you get the power to keep making all your own medical decisions, but here's the order of people we also want making medical decisions for you. Recently, the healthcare directive has gotten a lot more common. So, potentially here you might be able to get a copy of the healthcare directive if you don't already have one. Or at the funeral or the hospital, I should say, they might give you a copy of the healthcare directive. Obviously, I'm a little bit biased. I like the version that we use. But when it comes down to it, I'd much rather have you have a copy of the healthcare directive from the hospital than not have one at all. And we can always look at what you have and make sure that it actually says what you want it to, because unfortunately what I find sometimes with people who have documents that maybe they've done on their own, or maybe even an estate plan that they've done with an attorney in the past, is that they don't always say on paper what the person thinks they say in their head. So in your meeting, if you do have any documents, we'd look specifically at what you have, and it might be the case where what you have is good enough and you don't need to do anything different. But I like to at least have an independent look at it and make sure that it says what you do in fact want it to. So now there's just a couple kind of catch-up slides. Again, the medical assistance planning, we already talked about that. That's something that's very particular to you as an individual, and it deals heavily with what your finances are. Because to be frank, if we're worried about estate tax, meaning you have $3 million of assets, you're probably never going to qualify for medical assistance anyway. You're probably never going to spend all your financial accounts down to $3,000. So I wouldn't want you to start giving up too much power and control trying to qualify for something that you're likely never going to qualify for anyway. So that's why I say that it's very particular to you. So again, at today's presentation, we kind of just briefly touched about the different types of estate plans that there are. I know I fly through the slides really, really quickly, but I can certainly send you a copy of them. What I anticipate more so is that this is kind of just that little voice in the back of your head that says, oh boy, I heard one or two things that might be pretty relevant to me. I ought to set up a time to actually meet with Nick. So as I mentioned earlier when we started, we've got an office here in Wadena. I'm in Wadena every Wednesday. Otherwise, I bounce around between Sauk Center and Alexandria. That's where we have other offices as well. We'd be able to set up a time where we got an hour set aside where we can talk about your scenario specifically. And as long as you mention that you came to the presentation here, then we don't bill you for that initial consultation. So that can be really helpful as well, but make sure you mention that when you're scheduling the appointment so that way my assistants can know to make a note of that. The last slide that I get, the last question that I get very often is, when do we have to update our estate plan? Well, oftentimes there's not one singular answer. It's not like the documents are only valid for 5 years or 10 years or something like that. But what I usually tell people is if there's a major change in the family, specifically somebody who you thought was going to be in charge, if they pass away, that's a good time to come in and look at it. Other times is if there's very big valuation shifts, maybe things all of a sudden went up a lot in your investments and you go, boy, now I might have some more tax considerations to keep in mind. Otherwise, it says every 3 to 5 years. Personally, I think you can probably wait a little bit longer than that before you actually come in and talk with an attorney. But I would say every 3 to 5 years is a good time for you to take out your documents and just read them yourself real quick and say, boy, are these still the people that I would want to be in that order? Because what I find all too often, I already mentioned it once, is people come to me, they bring me their documents, and they tell me what they say, but what they say isn't actually what they tell me. So we want to make sure that your documents do say what you want them to, so that we get the right people to be put in charge. Because honestly, one of the worst things is when families come in and they say, oh no, that's not what mom and dad told me the documents were going to say. So we want to make sure that they are up to date and that you have copies of them. So we keep copies of everything that we draft. Our firm's been around for over 100 years. I got a financial advisor that I work with that jokes, if Nick gets hit by a bus, there's going to be a new Nick to replace me, because my predecessor's name was actually also Nick, and we both do estate planning specifically. So I guess that's a prerequisite if you're going to be hired by Pemberton. But again, your documents aren't sitting in my basement or something like that. If I get hit by a bus, retire someday, which unfortunately is going to be a while from now, at least then you've got your stuff safe still. So we got a couple more presentations, a couple more presenters, but I'll be around here at the end. If you have any questions, you can feel free either to ask them in front of the whole group, or you can find me individually, and then we can talk about your scenario if you got something you just don't want to ask in front of everybody. But with that, I'll turn it back over. Want me to take this off here? Sure.
We're green. We're green. Okay, we're good. But again, my name is Pat, and I've known Joe for right around 13, 14 years. I really enjoy working with him, coming up to Wadena and spending some time up here. And whenever I speak to a group like this, I like to share with you that I have a bit of a secret hope for everyone who's here tonight. And that hope is that you look at tonight as a starting point. It is fantastic that you took the time to come in here this evening, but if you turn around tonight and go home and you don't do anything with what you learned, you're not going to help anybody that you leave behind. And the reason I share that with you is because there's not a seminar you can come to, there's not a book you can buy, there is not a web page that you can go and look up the answers to your questions about how these things work in Wadena the way you can have them answered sitting down and talking to Nick or talking to Jeff about the funeral planning and things like that. So that's what I hope all of you do, is take some steps after we're done here tonight and do a few of these things. I'm going to take you through as quickly as I can 10 questions that we get at the funeral home all the time. I looked at those green papers, so some of these I'll go through pretty quickly, others I'm going to spend a little bit of time on. But the first thing I would like to share with you is the word funeral itself. You're going to hear me say funeral a lot tonight, and I want to share with you what I mean when I say that word. All I mean is a gathering of people after someone has passed away. All right, now that may be a very formal gathering, might be an informal gathering. You might have it at your church, you might have it in this room right here, you might have it at your house, and you might not even call it a funeral. You might call it a celebration of life or a memorial service or a tribute. So when I say funeral, I mean all of those types of things. And what I want to share with you is, I don't care where you hold it, I don't care what you call it, but I think having some kind of a gathering after you die is an important thing to do. It serves so many purposes that we don't always stop to think about the value of getting together and sharing about our loss and talking in an appropriate place to have those conversations. Now, you hear people all the time say, I don't want a funeral, or I'm not going to have a funeral. And I let those folks know I agree with them. I don't want a funeral either. Okay? I'm in no big hurry for that day to roll around. And even if you don't plan for some type of a funeral, there are still questions that need to be asked. There are still decisions that need to be made. So you do want to spend a little time ahead of time sitting down, talking with Jeff, talking with Joe, and putting a pen to paper and giving some kind of guidance to your family. If you don't have any type of a gathering after you pass away, I can almost promise you the people you leave behind are probably going to have one anyway. Now, they might have the kind of gathering that I talked about where they get people together, or they might have the kind of funeral that goes on for weeks or even months at a time. This has been when there's been no funeral, no gathering, and someone comes up to you at church on Sunday morning and says, did I hear right? Did your brother die recently? And then a different person comes up to you in the grocery store. And then someone else comes up to you at the football game on Friday night. These aren't really appropriate places to have those kinds of discussions. That gathering serves that purpose to do those things. Another thing that happens when you have a funeral is it allows the people we leave behind to connect with each other. One of the things that we witness all the time at funerals are people taking out their cell phones and sharing phone numbers, because you had Susie's number and you had John's number, but they didn't have each other's number. And so again, it gives them that opportunity. A couple other good reasons to have a funeral. I hear people say all the time, Pat, the people that we used to do things together with don't call me anymore. And sometimes people will actually avoid people who have suffered a loss. That's hard on those types of people. And in our defense, we say things like, well, I didn't want to bring it up, or I didn't know what to say. And what I want to share with everyone that's here today, it's okay to bring it up. It's okay to ask that person whose husband or wife or child passed away. It's okay to ask them, how are you doing? And while there are no magic words that we can say to make it better, just being a friend and just listening can help to make it better. So don't be afraid to bring it up and ask those folks, how you doing? And what I always let people know too is if someone who has suffered a recent loss, if you extend an invitation to them and they turn you down, make another invitation down the road. Don't just do it once and give up, because they might not be ready yet. that first time you ask them, but the second time they could very well be. The number one thing y'all checked on those green papers was how much does a funeral cost? So let's talk about that. I'm going to give you some pretty specific answers to that question. But before I do that, I would ask each of you, what do you mean by a funeral? Walking up to Joe and saying, hey Joe, how much does a funeral cost? Is like walking up to the Ford dealer and saying, how much is a pickup truck? Because you can get a pickup truck for $2,000, you can get one for $20,000, you can spend $80,000 or more on a pickup truck. And funerals are kind of the same way. What do you want it to look like? What do you want it to do for you? Where do you want it to take you? So anyone who's taking notes tonight, if you are taking notes, I would ask you to write down 3 numbers. Write down the numbers 6, 9, and 15. $6,000, $9,000, $15,000. Those are average costs in this part of the country that people actually spend for their funeral depending on what kind of funeral it is they want to have. Let's start with that $15,000 number. That's what we would call a traditional casketed burial. A person dies, the funeral home comes and gets the body, they bring them back, they do the embalming, they bathe them, they dress them, they place them in whatever casket was picked out. Typically we have a visitation the night before, a funeral service the next day, and then we all go out to the cemetery and we bury that casket. The $9,000 figure could be a couple of different things. That might be everything that I just described, but instead of doing it with a casket, we're doing it with an urn. Okay, so we're still having a visitation, still have a funeral service, and still go out to the cemetery and bury that urn. Or that could be something we call a simple funeral or a simple burial, and I'll talk a little bit about more in detail about that in a moment. But with a simple burial, we're taking an unembalmed body, placing it in a casket, and we're burying that casket pretty quickly after the death has occurred. Okay, so I'll give you some more details on that in a minute. And then the $6,000 figure would be more of what we call a simple cremation. We're probably having one gathering. It's not a real big one. We're not buying lots of food and lots of flowers and different things like that. Now keep in mind, these are not necessarily the prices at Schuler's. These are the average amounts in this part of the country that people actually spend. And because they're averages, could you spend less than what I just told you? Of course you could. And I asked Joe before the program, he said it's okay if anyone wants to spend more than average. Okay, so just don't feel like that's a hard cap or anything too. But we wanted to give you an accurate picture. Now when you talk about how much does a funeral cost, we need to talk about a group of expenses called cash advance items. What's a cash advance item? These are things that the funeral home makes no profit on. The funeral home doesn't provide these items, but they show up on your funeral bill. These are things like death certificates, opening and closing the cemetery, renting a room to have the service at, providing a lunch, a musician, clergy honorarium. All of those people want to get paid before the funeral. So what Joe will do as a service to your family and under their direction, he will advance the cash to all those different places, and then that just shows up on the funeral bill. And Joe does not pad the bill. So if your family picks out a lunch that costs $812.16, $812.16 is what Joe writes on that bill. The reason families like that is because what typically happens to our credit cards and our bank accounts when a person dies? We can't use those anymore. So your kids come back to town, maybe they're putting the flowers on their credit card and another kid's paying for the lunch, and then they have to wait for the estate to be settled in order to be reimbursed. It's much easier if they just have one bill to pay at that time. And the other thing about the cash advances that you want to know, they can easily be 25 to 33% of your bill. They can add up very quickly. And what do you think has happened in the last year to the cost of cash advances? Yeah, they've gone up pretty steeply, just as everything else has, unfortunately, in our economy these days. Also, when you talk about how much does a funeral cost, there's a document called a general price list. A general price list, or a GPL. What is that? That's a document that the federal government says every single funeral home in the country has to have a general price list. It has to follow a certain format. It must include all sorts of different charges. You as a consumer can walk in the front door of any funeral home in the country and you could say, I would like a copy of your general price list, and by law they must give it to you to keep. You don't have to tell them where you live. You don't have to tell them what your name is. You don't have to tell them why you want that price list. That is your right to have that. Now, I would suggest a better way to get a general price list. Instead of just walking in the door and grabbing a copy and going home and trying to look at it, call ahead of time and just ask, is there someone who could sit down with me for half an hour on Thursday morning and walk me through the price list? And the reason I recommend that is it can be a little confusing to try and decipher one. And then that way you can share, well, here's what I'm thinking about doing. And that person at the funeral home can show you, well, here's what those costs would be. And a good funeral home like Schuler's is going to keep working with you on that estimate until they get it to the spot where you're feeling comfortable with it. So the last thing I'll share with you about how much does a funeral cost, the best way to answer that question, come on in, sit down, spend some time with Jeff. He's the gentleman in the red shirt that you met when you came in tonight, and he'll be up here at the end of the evening too. He'll sit down with you, he'll walk you through all your decisions, he'll share with you what the costs are, so when you're done meeting with him, you'll know exactly how much does a funeral cost. Let's talk a little bit about cremation. Every single funeral home in Minnesota can provide cremation services to you. There's no reason to join a cremation society. They aren't anything special. They're not nonprofit. They're just funeral homes operating underneath a different name. So your local funeral home can do that for you. If you're someone considering cremation, the great thing about choosing that is you have lots of options, you have lots of choices, and there's all sorts of different things you can do. But the bad thing about choosing cremation is you have lots of options, you have lots of choices, and there's all sorts of different things that you can do. When I first started helping folks plan funerals 35 some odd years ago, I really only had to ask them two questions. I would say, which casket are we going to use? And are we going to have ham or turkey? That's really, because all funerals were the same back then, and they're not all the same now, and I think that's a good idea. Now, when it comes to cremation is not a type of funeral. And the reason I mention that is you do have folks sometimes will say, well, I don't need to do any planning because I told my kids I want to be cremated. Respectfully, but you really have helpful information, but I want to be buried. Good to know. Happen right away when you die. What's going to happen a couple days later? What's going to happen in a week? So all cremation is just a form of final disposition. Anything that Joe can do with a casketed funeral, he can do with the funeral that involves cremation. So as we get into this, the first thing that your funeral director might ask you is, when do you want to be cremated? And what are about half of you thinking right now when I ask that question? After you're dead, right? Okay, so where am I going with that? Do you want to be cremated after the funeral? Do you want to use a rental casket or a cremation casket, have that visitation and then do the cremation? Do you want to be cremated pretty quickly after the death occurs and then maybe have a gathering with the urn and some pictures or videos or things like that? One of the nice things about working with Joe is he does offer a third option. And here's the first piece of homework for all my cremation consumers that are in the group tonight. I would encourage you to ask the people who are closest to you, would it be helpful for you to see my body after I die, but before the cremation takes place? And if the answer to that question is yes, what Joe can do is he can bathe the body, he can dress the body, he can lay it out nicely, and that immediate family member can come in, kind of say their goodbyes, and then the cremation can take place afterwards. Because you might have 4 kids, 3 of them live in the area. They were able to get to the hospital or the home or wherever and kind of say their goodbyes. But you might have a daughter who lives in Milwaukee, and she wasn't able to get back. It might be helpful for her to have that short period of time to kind of say her goodbyes prior to the cremation taking place. When it comes to cremation, you do not have to be embalmed. You do not have to buy a casket. Now, you might do one or the other, or both of those things, depending on the kind of funeral that you want to have, but there's no law that says you need to do that. Likewise with urns, most people will buy their urns from the funeral home, but you don't have to. If you have something that you want to use as an urn and it has meaning to you and your family, Joe will certainly work with you. I have seen people use cookie jars and Folgers cans, tackle boxes. I even saw there was 3 daughters, and they used mom's big gaudy handbag that she took with her everywhere. So they use that as the container for her, to take on her final journey with her. So again, we'll work with you to make meaning to this. Now let's say we've got the cremation done, we have them in a container. What do you think happens to the majority of cremated bodies in this part of the country? What might we do with them at that point? Any thoughts or suggestions? On the mantle? Yes, every soap opera has got somebody on the mantle. What else might we do with those cremains? Could bury them in a cemetery? Could scatter them? Yeah. There's a lot of different things we could do because frankly the state of Minnesota doesn't really care. Once the cremation is done, that's considered to be final disposition. Now in this part of the country we still bury most urns just like we would a casket. And a lot of times people say, well, I don't need cemetery space, I'm going to be cremated. Well, what happens is if my mother is to be cremated and I have her urn at home on the mantle, eventually I'm going to start thinking to myself, well, which of my kids want to take grandma's urn? And none of them probably want to take grandma's urn. So then I go looking for a cemetery or something like that. So you want to think these things through as we're looking at all these different things. Now, if you are the adventurous type, you could get made into a diamond ring. You could be part of a coral reef. You could get shot into space. This is something we're starting to see, is people take the cremains and mix them with soil and plant a rose bush or something like that nature. And then with all these different things that we can do, there's even a company where I live in Alabama that will load you all into 12-gauge shotgun shells and your buddy can give you a 21-gun salute. So lots of different things that we can do here. There are bird baths, garden rocks, sundials. I think we got a customer right there. He likes that idea, don't you? We can't scatter on land or water without the property owner's permission. So we just have to get permission. And so when I die, if I'm cremated, my wife could take me home and scatter me on our land. She doesn't have to keep a record. She doesn't have to ask permission. She can do that. If she buries my urn on our property, she would have to disclose that when she sells the house. And at that point, she's either going to have to dig me up and take me with her and her new husband, wherever they're heading off. Or the guy who bought the property might say, yeah, just leave him there. That's fine. So again, and I'm not against scattering, but I just want to pump the brakes on that thought a little bit. You might not always own that farm. That cabin might not always be in your family's possession. And if you scattered Grandpa out at the lake and then you sell the lake place, you just gave up the right to go have a chat with Grandpa. So again, I'm not against it, but sit down, have a chat with Jeff, tell him what you'd like to do. He'll walk you through all these different choices. I want to talk to you about simple burials because this is something that we're starting to see a little more of. When a person dies in Minnesota, we have 72 hours to do one of 4 different things. We either have to embalm them, cremate them, bury them, or refrigerate them. So with a simple burial, what we're doing is we're taking an unembalmed body, placing it in a casket, and then we're burying that casket within 72 hours time. It's a little more affordable than that full traditional casketed burial that I talked to you about. It's very simple. There are people who like the idea of being embalmed, or they don't like the idea of being cremated. Well, we don't have to do either one with this. For people that are concerned about it, it is the greenest option because we're not using any embalming fluid, turning on the crematory and burning those fossil fuels. And there are even biodegradable caskets. There are wicker caskets, burial shrouds, things like that. Now we're a little limited on what we can do if a person wants to do a true green burial. We're limited by what cemeteries will allow, and I'll talk about that in just a second. Not a lot of you checked this box, death away from home, so I'll go through this pretty quickly, but if you're traveling or you're away from home, what you want to remember, the very first phone call you should make if someone with you dies is back home to Wadena. Always call your local funeral home first when a death die. My wife doesn't know the first thing about the funeral homes in Phoenix, but she knows our local funeral director. So she wants to call back home, talk to them, let them find a funeral home in Phoenix to take care of us. That way they're going to be looking over her shoulder, and that will also save money. Because if she picks up the phone, calls that funeral home in Phoenix directly, they're going to charge her their regular retail rates. But if our local funeral director makes that phone call, they have what's called courtesy rates between funeral homes to help keep those costs down. If you're like me and you travel a lot, they do have a nice travel protection plan here. I own this. I travel all more information, but $25 one time. I never have to give another penny. I'm covered for the rest of my life anywhere in the world if I die more than 75 miles from my front door, which with all the traveling I do, for me it was just a smart decision to get that. But ask Jeff about that if you want to know more. Vaults, headstones, and obituaries. There is no state law that says you need to buy any of those three things. So if you do not want to run an obituary in the paper, you do not have to. If you want him to, Joe can put your obituary on his webpage. That way, if you have a relative who isn't in the area, they can go and they can print off a copy of that or something. When it comes to vaults and headstones, every cemetery is free to make their own rules and regulations. So what one cemetery may let you do, another cemetery may say, no, we don't do things that way here. So some cemeteries will say just flat markers. Some will limit the size of the marker. Some cemeteries will let you bury 2 urns in one grave, others won't. So we have a reference here at the funeral home. You share with Jeff what kind of, or what cemetery you're looking at. He can pull up that information and let you know what their different guidelines are. I want to talk a little bit about funeral trusts, and when I talk about funeral trusts, don't mix it up with the things that Nick talked about. His trusts are much more elaborate. These are special entities just for funeral dollars in the state of Minnesota. So that's what I'm going to talk about here. And before I get into this topic, Joe wanted me to stress to everyone who's here tonight, and we would like you to share this with your friends and your neighbors and your relatives as well. You absolutely do not have to prepay to pre-plan. Okay, so don't let the money part stop you from coming in and putting a pen to paper and making some decisions. Now, while you don't have to prepay to pre-plan, after the 7th or 8th meeting, Joe will stop answering the phone. Okay, we want to help you get it done. We don't want to turn it into a hobby or anything like that. And you heard me say prepaid funeral. In Minnesota, that's actually a misnomer. When you set up and fund a funeral trust in the state of Minnesota, you are not giving your money to the funeral home. It remains your asset. It remains your money. It is never under control of the funeral home. The funeral home could go out of business. The funeral home could burn to the ground. It would have no impact on your funeral trust because it is your money, not the funeral home's money. So let me share with you kind of how these things work in Minnesota. There are 6 or 7 different insurance companies that operate in this area in the state of Minnesota. The only thing that they do is hold funeral dollars. They don't do car insurance or house insurance or anything like that. Then there is a fill-in-the-blank document with Minnesota state-specific language in there outlining the different consumer protections that I'm going to take you through here in a second. That is laid on top of that policy with an irrevocable trust assignment that turns it into a funeral trust under Minnesota state guidelines. So it is not just a bank account. It is not just an insurance policy. It's a very specific thing that is designed just to provide money at the time of death. So keep in mind, money in a funeral trust belongs to you. So how do these things work? First of all, they do grow income tax-free. So you don't get a 1099. You don't have to report that increase in value on your taxes each year. At the time of death, they pass outside of probate. So again, your kids aren't coming to town, putting the funeral on their credit card and waiting for the estate to be settled. These dollars become immediately available, typically within about 48 to 72 hours. Money in a funeral trust, and you heard Nick talking about medical assistance and Medicaid. It is a protected asset if you ever go into a nursing home. They can't go after the money in that trust to pay for your health care costs. Likewise, if you die owing someone money, creditors can't go after your funeral trust either. It's a specific use asset. If you have more money in your trust than you need to pay for your expenses, the extra money must be refunded to your family. The funeral home can't keep those extra dollars. You can use this money at any funeral home. And here's a bit of a nuance in Minnesota state law that I want to do a good job of explaining. In Minnesota, there's no such thing as a do-it-yourself funeral trust. You have to work with a funeral home to set one up, but you're free to take that trust to any funeral home in the world. You can't be locked into a funeral home in Minnesota. Other states, you can be. So Minnesota has some good laws when we kind of look at these types of things. It is reinsured by the Minnesota Guarantee Association, so there's an extra layer of protection there. Likewise, your file is your property. So any funeral instructions that you leave, if you want to transfer those to a different funeral home, that's your right in Minnesota state law. So again, important to remember. And I've saved what I think is the biggest benefit of these funeral trusts for last, and that's this. You can change your funeral directives at any time. So whatever you write down today is not set in stone. You retain the right to draw a line through your instructions or shred them and start all over again. So you're not locked into that plan. Can anyone tell me, if you can see it, what that is a picture of on the bottom of the screen up there? Have you ever seen one of those before?
A round to it.
That's around to it, yes. Or as they say where I live in Alabama, I want to help all y'all get around to it. When I meet someone new and they find out what I do for a living, they say the same two things every time. The first thing they say is, wow, that's a really good idea. I bet you my family would appreciate that. I'm going to do that. The second thing they say to me is, but those are some big decisions. I want to think about this a little before I write anything down. Coming from Minnesota, what typically happens when we think about things for a little bit? Exactly, absolutely nothing. So here's what I want to encourage each of you to do. The funeral home has a really nice, it's a 14-page funeral and cremation planning guide. They will order them, they will pay for them, and they will give them to you for free. All you have to do is ask them for one. They don't want to order any more than what they need. But before you go home tonight, tell Joe, tell Jeff, yes, get me one of those planning guides, take it home, and do as much or as little as you can on it. It's kind of a question and answer, fill in the blank format. The first couple pages are really easy. Where were you born? What's your mom's name? What's your dad's name? Where'd you go to school? When did you get married? You know, those types of things. And then as the book goes on, the questions might get a little more difficult. It starts asking you for some specific things. And I've never seen anybody completely fill the book out. But to go back to the reason I brought this up is you can change those plans anytime you want to. So that's why I encourage you, get one of those books now, address some of these questions now, and that way if you never do get around to it or you think about it, at least you've done something to point your family in the right direction. You don't have to necessarily outline every single step they should take, but just point them in the right direction, north, south, east, or west. I promise you, someone someday will be very grateful if you took some time to do that. Now, I'm not going to go into this topic a whole lot because Nick did a great job on it here. But as we get older, typically we all worry about what happens if I go into the nursing home. And Nick talked about that Medicaid planning and the different things, and I can't encourage you enough to take that into consideration because that 5-year look-back period is a long time. And it can tie your hands if you wait too long. But here's my pop quiz for everyone who's here tonight. 2 questions, very simple questions. My first question for all of you. Please raise your hand if you're going to live in the nursing home someday. Okay, I got a maybe up here, over here. So here's my second question. This one's a little easier. This time I want you to raise your hand if you think there's a chance the guy sitting next to you might go to the nursing home someday. So the wives' hands, go fly up there. And let me just take a minute. I'm not trying to make light of that. That's a hard thing to do, to put someone you love and care about in a nursing home. So please don't think I was being flippant or anything. But that's what we think, isn't it? Never going to happen to me. Well, sometimes bad stuff happens to good people. Nick did a great job of going through all this. But what I want to remind you of is that funeral trust is a protected asset if you ever go into the nursing home. So just another good reason to take a look at that and do that ahead of time. I'm going to skip through that to try and start wrapping things up here. And I do want to talk just a little bit about emotions before I wrap things up tonight. And would you believe me if I told you sometimes families get in arguments at the funeral home? Probably not a surprise. Now, I will say most families don't. Most families get through that with dignity and class, but sometimes it does get a little ugly sometimes. And you know what I have discovered over my time in this line of work is they're not arguing over what 3 songs to play for Mom's funeral. They're arguing about stuff that happened 35 years ago and has never been resolved. And you're the Supreme Court of the family, and now you're gone, and boy, the gloves come off, and here we go. So having those funeral instructions written out, it just buys us some time before some of the disagreements come about. Another thing that can happen is your kids could have very different financial circumstances. I don't know anything about your family, but I bet you maybe 1 or 2 of your kids is doing pretty good for themselves, and maybe 1 or 2 of them are struggling. In my case, I have 1 brother and I have 1 sister, and my mother is still alive. So let's say my mom dies next year and her funeral bill is $15,000. Well, that's easy math. We each write out a check for $5,000. But what happens if we're sitting there at the funeral home and my sister doesn't have $5,000? How is she going to feel sitting at the table? And maybe she feels like she shouldn't even say anything because she doesn't have a right to, because she can't pay her share. Well, again, that's another reason we got a funeral trust for my mom, so we don't have to worry about that happening. And I do need to disclose to everyone who's here tonight, my sister caught wind that I tell that story at seminars, and she wants y'all to know she does have $5,000. So just not throwing her under the bus. And here's my last piece of homework for each of you. I want you to go home tonight, and I want you to call up your kids and tell them you need $10,000 in 72 hours. Any of you got kids like mine? Probably not going to happen. That's kind of what happens, though, when someone dies, isn't it? All of a sudden it's Thursday and we have a bill that on Monday we had no idea was coming our way. So there's just so many good reasons to take a look at this. And then the last thing I'll share with you about these funeral trusts is you don't have to fund it all. Well, number one, you don't have to fund your funeral planning at all. But if you do, and I think it's a good idea to do it, you don't have to put all the money in there at once. Talk to Jeff about how you would like to get that trust funded, and there's a funeral trust for every single budget. Some people will put it all in at once. Some people will put in half and they'll never put in another dollar. Well, at least half the funeral is taken care of. Some folks will say, well, I want to put in a little bit every month or whatever. So just let Jeff know what you'd like to do and he'll work with you to get that done. So anyway, I want to just skip through this to my last thing here tonight because you've been sitting here a long time. And Nick dropped a lot on you. I dropped a lot on you. Where do you start? What do you do with this? Each of you should have had on your chair a piece of paper, kind of a peach-colored thing, and it'll say Program Evaluation Form. If each of you would find that form and do 2 things with that with me for me right now. First of all, Joe would like to do another program like this, maybe this fall. If you have suggestions for topics or speakers or anything at all that you think might be interesting or make for a good program, please tell us about it on that form. The second thing I want you to do with that form is write down your name, write down your phone number, and tell Jeff how many of those planning guides to order for you. If you're a married couple, you'll need 2, 1 for each of you. If you have a brother or sister in town that couldn't come tonight, like to get one for them, by all means, don't mind doing that. We just don't want to order more than we have to. And then when you're done with that form, just hand it to Jeff or turn it over, leave it on your chair. We'll pick them up. We did a program down in Eagle Bend this morning, and so we'll add that number to this number. We'll place the order. When they come in, Jeff will give you a call, and what he wants to do is just sit down with you and get you started. And someone asked me this morning, well, Pat, how long is a short meeting to get started? That's entirely up to you. Sometimes we sit down with folks and that first meeting is 5 minutes because they're busy and they just want to get the book and get started. Other folks have been thinking about this for a long time and that might be an hour-long meeting, but that's up to you to decide how long you want to do that. So what I'm going to do at this point is we're going to bring Joe back up and Jeff back up and Nick back up. We'll take some questions, and then we get to do the door prize drawing, which should be interesting to see what kind of a door prize a funeral home gives away. So that might be interesting to see. So, Joe, I'll turn it back over to you. I'm going to turn this off.
That's great. So Any questions? As Pat said, that's what we're here for, is to answer questions. Do you guys, any questions off the top of your heads that you want to ask?
I'm not sure how they decided how much money we needed to put in there, but when the funeral came up for my dad, there wasn't enough money. So
Right.
how do you know what you're supposed to be? My other sisters have money. I'm the one that didn't have money. And so they had no problem, but they told me,
Sure.
if we're gonna split it 3 ways, this is what you need to come up with. And they knew I didn't have it. So how do you know what to put in there?
Well, the best thing to do, and what we do here, is we base it on real world dollars. So what it would cost today to do the funeral that you would want to have. And so any money that is set aside goes into an interest-bearing account, and we all know what the market is. Sometimes the interest does well, sometimes it doesn't. But when it comes to justifying these dollars, for instance, for Medicaid purposes, when the county looks at the estimates, it has to be based on real world dollars. We can't just say, well, I think $25,000 will take care of it. We have to say, you know, the embalming is going to cost this much, and the visitation the night before is going to cost that much, and we're going to add them up. And yes, we can look at things and kind of say, what's the big picture, and then you compare it down from that. But we are kind of restricted to deal with the dollar amounts that we have now. We don't. No, because prices change. Yeah. Which is always important to, if you've already started this process, to reevaluate. Periodically, to look back. You should be looking back at your will and at your health care directive. You should also be looking back at what the finances, because the world has gone crazy as far as costs are concerned. And the old way of doing things, the way we did it for a million years, was we used to set this up in a CD in the bank, right? Well, since 2008, there has been virtually no growth on any CD in any bank anywhere. You know, you get 0.006% interest rate on it, and that $10,000 policy made probably 36 cents last year, you know. And so a lot of people did get caught behind the 8 ball when it came time to paying for a funeral, because they were thinking this was growing the whole time, but interest rates just weren't there. Periodic review. I mean, I don't want you dwelling on it. As Pat said, he doesn't want us to be talking every 15 to 20 minutes. But periodic review is always a good thing to make sure that you're on track for what your wishes are.
So with medical assistance right now, is there a limit on the total amount that they would say is okay to be in there? Like if you're just gonna say, as of today, is 15,000 too much, or would
Right.
they say that's okay?
They basically don't have a limit. I mean, you can't put $50,000 in there because you don't need the $50,000. Okay. But what we do is we go through, and when Joe's talking about real world dollars, we itemize. Everything has to be itemized. The government.
And then what you're gonna put in there.
Right.
And if we have a funeral and the person's been on medical assistance and there's extra money left over, it said it went to the family, but if they've been on medical assistance, does the county get the difference?
Yes.
To clarify, that money goes back to the estate, and the county has a claim on that estate. Yeah. So when you know, the estate is going to be what it is at the time of death. It's either you're paying your own bills, you're not getting assistance from anybody, your family is your estate. But once you get someone in there assisting you, once you have someone who's financially supporting you, they have a claim on that estate for reimbursement. You want to?
2,000 over, the county will take that 2,000.
Exactly, which is why you don't want to put $25,000 towards a funeral that you think is only going to cost $12,000 or $15,000, because all you're doing is saving $5,000 or $8,000 to give to the county later, when you could be using it to your benefit now. So again, sticking with those real world dollars, knowing that it is, you know, it's a risk, but knowing that it's going into an interest-bearing account and it is going to grow, so as prices change, hopefully it'll at least offset those changes. And the further along, we do have some families that says, you know, you give them an estimate, they know exactly how much it is, but at this point, they're only ready to do, let's say $10,000 is the estimate, but they're only comfortable doing $7,000 at this point. That's just all they can do. Well, then they go home and they say, kids, I've paid for the funeral. Well, unfortunately, they knew from the start that that didn't happen. But we hope that the interest grows on that account, helps offset the changes that occur over time, maybe even make up back in when we were getting a decent interest rate of 5, 6, 7%, we would figure that interest rate will eventually pay for that funeral if you underfunded it. That's just not the case in the world that we live in right now. But
So this is getting interest, but not very good even in the trust or what?
interest rate, you're the interest rate.
Interest rate right now is just shy of 2.4%. But one thing to remember, the interest in the trust is all non-taxable. So if you have to pay income tax, that's not something that your tax person is going to have to deal with. Because the interest you get, 2.4 is probably equivalent to 4.5, depends upon your tax bracket, of taxable income that you just give to the government anyway. So, yeah, it's all tax-free.
And unlike a CD, unlike a CD though, it is, when it comes to an insurance product, it's always age-based also, what that interest rate is going to be. So always a good thing to check though when you're pre-planning. Yep, absolutely. I'm ready.
I just want to put in a good word for Nick. I had breast cancer diagnosis, and they told me at the hospital, you better get your life in order. And so I dragged my husband over there, and we have two special needs kids, and he was able to do a lot of stuff that I didn't even know what I didn't know. So I just want to put in a good word for him. There you go. In very specific ways for us.
So for those of you who didn't hear online, got a plug for Nick.
I'll pay you later.
He's looking for that better interest rate. So no, excellent. That's great to hear, and we do appreciate him being here, and his knowledge is
That's not straightforward. Like
right.
downloaded a will online for my mom and dad because it was so simple, and it worked as far as I can tell so far. But my stuff was a lot more.
More complicated with the family.
Let's do the door prize. If anybody has any more questions, we're going to be hanging around here for a little while. Tell them about the cookies you set out so you don't eat them all.
Yep.
And just come on up and we'll answer your questions.
Sure. And those of you online, thank you very much. I know we had some audio difficulty. If there's something that you missed, review it. You may want to check out a similar program this morning. You can check out that recording also. Nick gave you a ton of information, so it's kind of nice to be able to hit rewind and listen to some of that stuff again too. So once again, thank you, Nick, for being here. And so online, we're going to shut you off. Thank you for being here. And otherwise, we'll take care